Good afternoon. My name's Tim Wilson. I'm Australia's Human Rights Commissioner, and welcome to this live web stream to talk about the issues that you've raised directly with me and what you think is important as part of Australia's human rights discussion. If you want to submit questions still, you can do so, and you can send them at events@humanrights.gov.au, or you can tweet them to me directly. Someone else is watching on them, don't worry. The Twitter handle is @TimWilsonComAU. If you raise those questions, I'll be giving them and showing them, and I'll try and address them in the short time we have this afternoon. The first question I have is from Amanda. And Amanda asked the question, how would the Commissioner, me, suggest seeking a balance between the rights to freedom of opinion, expression, thought, conscience, and religious worship, and other important rights such as the right to non-discrimination outlined in the International Covenant on Civil and Political Rights? Well, it's a really good question, because it's the one we toy with on a daily basis, the Human Rights Commission. Because in the end, when you're talking about those basic freedoms, about freedom of speech, about freedom of association, about religious worship, the standard principle in a liberal democracy and a human rights compliant approach is that everything is legal until it is made explicitly illegal. We have a civil right to introduce anti-discrimination legislation in Australia, which says that in the marketplace and other places that people shouldn't unjustifiably be discriminated against. So let's take a really concrete example, which is around religious freedom, and that religious institutions have exemptions from anti-discrimination laws and are allowed to discriminate against people on the basis of employment because they may live up or embody the values of that faith. My view is that that is a legitimate restriction, but within certain parameters. I think religion should be clearly establishing which roles are necessary to have people embodying those values, and make it clear so when people go to seek jobs or anything else, that they don't face discrimination they may not be aware of. I think there needs to be a degree of clarity, because in the end, they are communities, and to uphold the value systems and the tenets of faith and be leaders of that faith, they express that. But I don't think it should apply, for instance, to clients of services. And when we're talking about schools, I'm actually talking explicitly about kids. And I don't think that there should be a situation where kids are unjustly discriminated against because they may be a young woman who is pregnant but may not be married, or a young lesbian, gay, bisexual, transgender, or intersex youth that may be deemed to be inconsistent with that faith. I think that is personally unjustified discrimination. I think you can draw a very clear distinction between people who represent a faith and are supposed to embody those values, and those people who are recipients. In terms of law, of course, that isn't quite how it operates. Around the country, there are very different laws that operate at a state level which deal with different degrees of exemptions. Importantly, last year, the Sex Discrimination Act was amended, in many ways with the support of at least some religious faiths, to say that discrimination was unjustified in the provision of aged care services. And that's a significant change as well. So it's part of a constant balancing exercise. But I think when you talk about those basic freedoms, we should be talking about them being unlimited, and the restrictions against them should be justified. And that's how you seek the balance in a human rights framework. The second question from Amanda is that there is a particular question with relation to freedom of speech, and that it's not absolute, and that is correct. Although, again, I stress strongly that freedom of speech the deference should be given to more speech, and restrictions should be justified. In comparison to the Racial Discrimination Act, which actually limits what people can say and then prescribes the basis in which people can lawfully say something. And Amanda's asking the question, when will there be a change to deal with not to anti-discrimination law around sexual orientation, gender identity, or intersex status, and issues around vilification, abuse, and intimidating conduct, which is currently excused from the law around LGBTI people. And the same it is, by the way, for speech on the basis of gender, on the basis of disability, on the basis of religion, or any other proposition in federal law. And this very much takes us back to the discussion that I think we were having earlier in the year around the Racial Discrimination Act and why it should be reformed is because, one, there's no provision that's equivalent for other people apart from on the basis of race, national origin or ethnic identity to restrict speech that may offend or insult or humiliate, but equally those are an inappropriate standard, whereas something around intimidation or harassment is not, because there's very clearly a restriction or a limitation on somebody else's human rights if somebody engages in direct intimidation or harassment. So I think we should be looking at what public harassment means, how we define that in law, and we should be taking it beyond the issue of race and saying it doesn't matter what the purpose is. If somebody is being harassed or somebody is being intimidated, that law should apply consistently. And that's what I was arguing. If you go back and look at my articles at the time during the debate around the Racial Discrimination Act, I was advocating very strongly. You can find those articles at humanrights.gov.au. So in answer to your question, when am I going to start advocating that? The honest answer is I've already been doing it, and that's why it's important to have a robust, respectful and mindful discussion about free speech and how to seek reform. But it has to be across the board. It can't be for one group or the other group. It has to affect every Australian. We had another question from Nicholas, who identifies as a human rights activist. In fact, he's asked a lot of questions, but there's one in particular that I should seek to answer, which is, what is my opinion on the need to establish effective rules of the game for the purposes of enabling the world's poor to benefit from globalisation? That's a pretty broad question, Nicholas, but we do actually have certain degrees of international rules under the World Trade Organization. Having a bit of a background in trade policy, I'm acutely familiar with that. But there are issues in the end, even with those rules, because in terms of creating economic opportunity for people, people need the foundational principles in law in their own countries to enable them to do so. Property rights, one of the most important human rights there is, needs to be established, recognised and tradable in law so that people can extract the value of what they own, whether it's their personal capital, meaning their intellectual property, or their physical labour, so that they can seek employment and seek out opportunities for themselves. In terms of physical property, so that they can take those property rights and turn into equity and take risks and mortgages on the future so that they can develop it and grow. And this is one of the main challenges we face in this country, particularly with relation to Aboriginal Australians. My personal view is that there are too many restrictions on Aboriginals and their land rights, and it disempowers them and disengages them from being able to extract value and create opportunities for affordable housing, jobs and development in their community. So it's not just an international issue, it's a local issue as well. And so the way you deal with that is by establishing clear and open property rights, and for then people to be able to do what they can do. And to give you a sense of this, currently there are restrictions on native title, which means you can't use it as the basis for seeking finance or a loan. Like I did when I bought my house, I went to the bank and I said, this is the property I'm going to buy, this is the equity, and then you get a mortgage. Those sorts of things don't apply for Aboriginal Australians with relation to native title. I think that should change, but I think that should change in the context that Aboriginal people obviously can't give over their land to a bank if they're not able to pay the mortgage, because they have an ongoing connection to that land and an ongoing relationship through that title. So we need to look not just at property titles, but then the financing mechanisms and how we price risk as part of that discussion. I know that's a very long-winded answer to your question, but I think it's a very important one at the international level and the local level, and no matter where you look at it, the issues fundamentally remain the same and need to be properly addressed. So thank you for your question, Nicholas. I had a question from Greg, who's particularly interested that this consultation is happening on International Men's Day. I have to confess, Greg, this is the first time I've heard of International Men's Day, but thanks for your question. But I do have to say that a lot of the questions around sex discrimination are the role of the Sex Discrimination Commissioner's portfolio, my colleague Elizabeth Broderick, and not explicitly my role, but particularly as a question about gendered violence and gender compassion and the gap that exists. And Greg's question is, despite men being the vast majority of victims of violence, I'd have to check that, Greg, I'm not saying no, but I have to check that assertion, and a significant proportion of victims of family and domestic violence and sexual violence, they remain unacknowledged as victims, and services for male victims of family and domestic violence are virtually non-existent. I have to say, Greg, I disagree with you on this. Firstly, as far as I am aware, women are by far the greater victims of domestic violence. But domestic violence occurs against men as well. And I agree with you that it's not raised up to the level that needs attention, nor, might I add, is domestic violence against women, which is an incredibly important issue across the country. So it's something that I think we need to do, but we shouldn't be treating it as one part or the other. We should be treating it as part of a whole discussion around domestic violence and how people shouldn't be committing violence, and identifying the underlying issues associated with it. So yes, it should be a priority. Yes, it should be a focus, but we shouldn't ignore the fact that violence against women, no matter where it is in the country, is horrific. And you made an assertion that it's greater. I'm not so convinced on that, but it is certainly an important part of the issue. But the rights of men are the same rights as everybody else in society. And when we're talking about human rights, we're talking about everybody in the country. And we're talking about the principles that unite us all. And everybody has a right to be free of violence, regardless of whether they're men or women or transgender, or they're any other particular identity group within society. So we have to unpack it, look at the detail, but it all has to be addressed as part of the same discussion. Then I got a question from Maggie. And Maggie's asking a question about what I think about euthanasia, child refugee status in Australia, people's right to congregate and protest, the elderly. Needless to say, there's quite a few questions you've raised, Maggie. The central proposition around euthanasia, I think the foundation of human rights is that people own their own bodies and they should be free to pursue their lives, their opportunity, and their enterprise. But anything at the beginning and the end of life is naturally challenging within a human rights framework. I'm not convinced people have a right to die, but I do think there's a proper discussion that needs to be had about how and in what circumstances, and with a degree of consent and safeguards, people may be able to at least refuse to receive medical services. But that is a complex discussion, and it's not as easy as saying I support or oppose. It is one of those very difficult issues to answer, and very much often comes down to people's personal moralities. And I can see situations where euthanasia, I can understand why people want to go through with it, but equally, I can see situations where that may not be the case, or I have a different opinion. With relation to child refugees or people seeking asylum, particularly children, the Commission has held a very significant inquiry into the issues facing children in detention. A report on that will come out soon, led by Professor Gillian Triggs, the President of the Australian Human Rights Commission, looking at every step of the challenges being faced by kids in detention. I participated certainly in the earlier stages of that inquiry, but there's no ambiguity in my mind about the fact we shouldn't be seeing kids in detention. I think everybody agrees with that. It should always be one use as a last resort, but we should never even get there. And one of the things when I went to detention centres and talked to children and confronted me with it, and I'm quite open about it, is how much it can have a very real and human impact on young children, particularly those who have become aware of their surroundings. So obviously babies may not be aware of their surroundings, but when kids get to the point of 5, 10, 15, and they realise the conditions they are in, it has a very material impact on their health, on their world outlook, and it is not a positive thing for them. But it's also not a positive thing for our country, because in the end, if we want these children to go on and be adults in Australian society, we need people like Australians to have their full capacity, their full potential being realised. And I don't think that occurs when you put people in long-term detention, and particularly around children. So that is my answer around that. With relation to people's right to congregate and protest, of course, I am a big fan. I started this discussion by saying that basic freedoms like freedom of speech, freedom of association, and freedom of religious worship should be unlimited, and there should be restrictions that are justified. I absolutely support the right of freedom of protest and freedom of congregation, which in the end is just freedom of association and freedom of speech. And I think there needs to be very strong and clear cases why that should be restricted, which sometimes there is when it comes into competition with other rights. And a very clear example is that you can't just go and protest in somebody's home because it's a restriction on their property rights or restricted by their property rights. That is what I mean. You can't use freedom of protest as the basis to go around and vandalise people or harass people or anything else, because in the end, there is a tension and a competition between rights. But I think most Australians are sensible about how we should approach these issues, are mindful and respectful towards others, and the more often than not, people learn how to engage in a society in a civil and respectful way. Adam Smith wrote in The Wealth of Nations that people moderate their behaviour, their language and their expression so that they can continue to be held in the good standing of others. And that is, in the end, what drives most of us, making sure that we are respected and acknowledged equally by our peers, and that ultimately that comes from treating other people with respect as well. Do we have any other questions?
No.
We don't have any other questions. Thank you very much for your time, and thank you. If there are any other questions, feel free to submit them. But thank you for those who sent them in, and thank you for watching. I'm Tim Wilson. Have a good afternoon.